Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. It's been 1 month to the day since the lawsuit styled as Steve Goncalves et al. Versus Washington State University was filed, and there's been some discussion in the community and the public as to what is going on with the case. Why hasn't any discovery been served yet? Why hasn't a trial date been set on the court's calendar? Is this case not advancing as it should through the court system? The answer to these types of questions can be found in the document that was issued by the federal court jurist, Judge Emerson, on February 5th. In that notation to the parties, to the plaintiffs and Washington State University, Judge Emerson recognized that she is required to serve a scheduling order in the case per Rule 16 of the Federal Rules of Civil Procedure, which dictates that a scheduling order with these types of key events must be issued as soon as practicable unless there's good cause for a bit of a delay. And the court did find good cause for not yet issuing that scheduling order because of one thing: the motion for change of venue that Washington State University filed, along with a declaration in support thereof, back on January 30th, 2026. Now, while plaintiffs are given a lot of deference into what their chosen venue is, plaintiffs here clearly selected the western part of Washington because that's where Skagit County is located. That is the county where the state case was filed back on January 7th. And according to the complaint, the reason why that county was selected is because Washington State University has contacts in Skagit County. It conducts business in Skagit County, and one of the plaintiffs, the Chapin family, resides there. WSU removed the case to federal court in the Western District of Washington in the Seattle Division. That's where the case has been pending and proceeding since the 27th of January when it was removed. On the 30th of January, the defense filed their motion for change of venue along with a supporting declaration. If you look at 28 United States Code Section 1404, this governs changes of venue, and it states that for the convenience of the parties and witnesses, in the interest of justice, a district court may transfer any civil action to any other district or division where it might have been brought, or to any district or division to which all parties have consented. And what Judge Emerson stated in her notification was that she will not issue the scheduling order until the matter of change of venue is resolved. And that makes a lot of sense, because if she decides that it's proper to change venue from the Western District to the Eastern District of the state, then all of the work and the time and the effort and the setting aside of even a potential trial date down the line would have been for naught, because if the case venue changes, then the case is no longer going to be before Judge Emerson, and it won't be in the Western District. The defense is arguing for the Eastern District because the Eastern District is where Pullman is. That's where the witnesses are. They laid out in the declaration that was filed by a representative of WSU that Pullman is where the main campus is. And Pullman is where the names of all the witnesses that were disclosed in the declaration, potentially, that's where they work, and they live nearby the Pullman campus. They've pointed out that in the complaint, Mr. Koberger, although not a party to the action, his name is all over that complaint in terms of he went to school in the Pullman campus pursuing his PhD. He worked there as a graduate teaching assistant. He even lived in Pullman in off-campus housing. And they're also pointing out that Moscow, which is where the events that occurred at 1122 King Road happened, is right across the border, just a few miles from Pullman. So they laid out the case that it makes a lot of sense that the case should be in the Eastern District, where there are courthouses that are a lot closer to the Pullman and Moscow area than the current courthouse in Seattle is. The plaintiffs have not yet been heard from. As the statute says, the case could be transferred to a division where all of the parties have consented to. Well, the motion is silent as to whether the plaintiffs agree or disagree to this transfer of venue. A lot of times you'll see that statement that the defense, before filing the motion, contacted the plaintiffs to see if they would agree to the change. If the plaintiffs agree to a transfer of venue, it makes matters a lot easier, and it does not become something where there's going to be an argument between the two sides if the case should stay put or if it should go to the venue which is being offered up for transfer. The plaintiff's response to this motion is coming due. It will be interesting to see what their position is on it. And then ultimately on the 27th of February is when the hearing is scheduled on this matter. Oral argument will happen before Judge Emerson that day. And if there is disagreement, both sides will have an opportunity to say their piece, to say why it is that the case should remain in the Seattle division or if it should be transferred to a division that's closer to Pullman. After the court rules, if the court finds that, hey, the case should stay put, it should stay right here in front of me in my courtroom, then you're probably going to be seeing that case scheduling order coming out that the court is required to submit per Rule 16, which might even have a trial date on it. If the court rules that transfer is appropriate, then you're going to see the motion granted, and then the case will essentially be closed in the Western District, and it will be reopened anew in the Eastern District in one of the divisions, as whatever courthouse is decided upon. That's a matter that might even be discussed at the forthcoming hearing. And then it'll take some time. All of the documents will need to be transferred to establish the new case. A new judge will need to be assigned, and thereafter you'll likely see the case scheduling order coming out, showing when discovery deadlines will be, when the deadlines to any possible third-party defendants will be, when to amend the pleadings to add additional claims, and even potentially when the trial will be in the case. So a lot is depending on what the court rules after February 27th when she issues her order on the motion for change of venue as to the movement of the case forward toward potential trial in this matter. This will now conclude this episode of the Indie Zone. Thank you for joining us here today.